and decide whether you can.
Probably not tonight. Like, we'll probably get through a couple hours of it.
Consider such evidence.
I'm not going to listen to 7 hours.
You should understand that there are two ways that I can respond to an objection. If I say sustained, that means the evidence. That means that I granted the objection.
Once it gets into the trial, I'll be able to talk a little bit more about it because I kept up with this case pretty good when it first happened. But there's a lot of new evidence that they brought out in yesterday's part of it that we watched, that we listened to. So I'm sure I'll have a lot to say as it goes once it gets into the actual case.
And you should not consider the objected to evidence. If I say overruled, then that means I did not grant the objection, and you may consider the objected to evidence. You should not infer or assume anything from either lawyer's objections or the court's rulings. During this trial, the court will have to consider some procedures outside your presence. When that occurs, I shall excuse you to the jury room for a time. During these periods, the court will do its best to handle the matter as promptly as the law permits. On the other hand, I will appreciate your patience when this occurs. Now, the procedure in a criminal trial is generally as follows. First, the attorneys for both sides may make an opening statement to you. The opening statement is not evidence itself. Remember that what the lawyers say is not evidence. However, it is a preview or an outline of what they expect the evidence to show. Following the opening statements, the state has the opportunity to present evidence to support the charges against the defendant. And the defendant has the opportunity, if she so elects, to present evidence in her defense. This part of a trial is called the party's case in chief. In the state's case in chief, the state calls its witnesses and introduces any exhibits. When these witnesses testify, they may be cross-examined by the defendant. When the state has presented all of its evidence, the state will rest its case. Then, if the defendant elects to present any evidence, the defendant may call her witnesses and introduce her exhibits. Of course, when these witnesses testify, they may be cross-examined by the state. However, the defendant has no duty to testify or present any evidence whatsoever. After the presentation of the evidence, the attorneys may make a closing argument to you. At this time, the attorneys will try to persuade you to decide the case in their favor. Following the closing arguments, I will charge or instruct you more specifically on the law that directly applies to this case. Then you will retire to the jury room to deliberate and reach your verdict. This is not an exhaustive description of the criminal procedure, but hopefully it will give you an overview that will help you to understand the trial as it proceeds. It is your duty to follow any instructions that the court may give you during a case. Please remember to listen carefully to all the evidence. Don't jump to conclusions before the parties present all the evidence. Also, please remember that during a trial, it would be improper for you to discuss the case with anyone or to allow anyone to discuss the case with you or in your presence or within your hearing. This applies even to discussions among yourselves in the jury room or elsewhere before actual deliberations begin. Also, during a trial, you should not communicate with the parties, the attorneys, or any of the witnesses. Under this rule, you should not engage even in social greetings or small talk with anyone involved in this case. I've had situations where a juror saw a party or attorney in the parking lot during a break and was offended that the party or attorney did not speak back to the juror. They're not being rude. Please understand that these attorneys and parties should not speak with you as the trial progresses and will likely avoid speaking with you to ensure that there is no appearance of impropriety. So please do not take offense to the failure to speak with you as we go forward for the trial in the coming days. This procedure will protect you not only from wrongdoing, but from the appearance of wrongdoing.